4, 3, 2, 1. All right. Good morning. Thank you for attending today's follow-up workshop in docket number 2025-192A. On October 21st, 2025, the clerk's office published today's notice of follow-up workshop. In that notice, the clerk's office stated that the commission staff would conduct a follow-up workshop related to procedures for public witness testimony and customer public hearings. And the notice also reflects a scheduled workshop for today, Monday, November 10th at 11 a.m. or at the conclusion, of the workshop for docket number 2025-191A. If we can proceed with identifying who's participating in this workshop. Dominion Energy, South Carolina.
Good morning, Ms. Boyd.
Good morning.
I'm Chad Burgess. I represent Dominion Energy, South Carolina. With me is Michael Anselmo from the law firm of McGuire Woods, who is doing the same. Thank you.
Thank you. Piedmont Natural Gas Company. Oh, he does? Okay. All right. Thank you. Duke Energy Carolinas, LLC, and Duke Energy Progress, LLC.
Tekla Henderson and Lyle Trawick for the companies. Thank you.
Thank you. Next is Water Company, South Carolina Utilities.
Charlie Terani for the companies.
Thank you, Mr. Terani. And South Carolina Office of Regulatory Staff.
Ben Mustian on behalf of ORS.
Thank you, Mr. Mustian. Okay, so everyone, after reviewing the written comments after the notice of today's workshop was published in DMS, I didn't really see any suggested changes, but please correct me if I'm wrong. And I'm going to call on you at this point just to see if there are any additional comments regarding the proposed 103-841 regulation related to public witness testimony and customer public hearings. Mr. Anselmo and Mr. Burgess, are you okay with us starting with you again? Okay.
Sure. And Jocelyn, you're right. The company originally did not file written comments, but as is often the case, as you look through something, we did notice a few maybe minor suggestions.
Okay.
In a few of these, and I'll hit them. And I promise I won't belabor them like I did in the last docket. C states public witnesses may not be considered a party to the proceeding.
Mm-hmm.
Act 41 is pretty clear; they're not
Right.
a party, so maybe that should be a mandatory shall not be considered.
All right.
Just align with Act 41.
Yeah.
In G, we would recommend that the last sentence end with the word testimony. While I understand the intent as to why the chairman might move the order of witness around, we do not see a need to provide the commission with a full spectrum of opinions and ideas.
Okay.
I think that might have accidentally been imported from some of the rationale that we had discussed earlier.
Okay.
But I think you can end G after the word testimony.
Okay.
In K, it states any public witness testifying may extend his or her remarks in written form, but they must be submitted at the time. I think extend might best be served by saying submit. I think that was the intent of what we had discussed was you can do it orally and in writing, but you need to do it at the same time.
Okay.
By using extend, it connotes something different than reducing your existing comments to writing for the benefit of the commission's record.
All right, may I just stop
Yep.
you one second? Okay, I'm on J to allow an equal amount.
K, excuse me,
Oh,
K.
K. Okay.
It says may extend his or her
Yes.
remarks. The intent, I think, when we had our previous discussion was you can submit your comments in writing when you give them orally, but they should be the same, obviously, 3 minute. Extend may connote to someone they can do more than what they said at the hearing.
Okay.
So if we could just swap extend and make it submit.
Okay.
And everything else is good. In K, in subsection L, the last sentence, testimony may be recorded. I think our experience is everyone is recorded. I didn't know if the commission wanted flexibility to record these or not, but this is a very minor nit. You could swap may.
Will be recorded.
Yeah, or
because-
is.
Yeah.
As
Is
testimony
recorded.
is recorded
Okay.
or will be, yeah, either one.
All right.
Just so people know that they're coming in and it's being recorded.
Yeah.
And other than that, we thought the additions in M about preservation of objections, et cetera, is a good add. The cancellation language looks good. I think overall, those are the minor comments that Dominion had.
Okay. Thank you very much for those comments. And then Mr. Richardson. Okay, Ms. Henderson and Mr. Trawick.
Thank you, Ms. Boyd.
Mhm.
The companies appreciate the time and attention you and your staff have dedicated to this. Dominion sort of draftsman changes, I think, all make sense. And our comments were that the proposed draft regulation is consistent, we believe, with the appropriately implementing Act 41, and we appreciate the opportunity to comment on it.
Okay. Thank you. Mr. Terani?
In much the same way, I don't have many comments. The subsection K still does give me some heartburn. I'm not sure that saying that changing extend to submit solves the issue, and this is why.
Okay.
This happens a lot. You know, somebody comes to the hearing, they want to submit their bills, they want to submit something or other, and it's 90% of the time not a problem. A statement. However, I think the chair needs to have some language needs to be added that says something to the effect of in the discretion of the chair. Reasoning being, there's no way to effectively limit the written comments. So, you know, Mr. Anselmo said if they want to reduce their 3 minutes of testimony in writing, they can. Well, who's to determine what that is? And so when the one guy that comes in or gal and puts a book into the record, essentially that customer can't be subject to cross-examination because what are you going to do? Read it during the public hearing and then cross-examine them? So there just needs to be some discretion on the part of the chair to either allow or disallow it. So if, I think of one particular public witness who used to come during the VC summer siting hearings, and he had technical background, and he would submit these detailed analyses. I mean, somebody like that, what are you going to do? Cross them? You don't have time. So that's my only comment.
Okay. I was just looking, do you think perhaps beginning K would at the discretion of
Yeah.
the chair? Okay.
Yeah.
All right. Thank you.
Oh, wait a minute.
Yes, sir.
No, if you begin K, then you still have the second sentence.
Yes.
Any public witness may submit, because right now it's just a right, the way it's written. And I think you need another at the discretion of the chair.
At the second one too. Yeah.
Yeah.
Thank you very much. Let me know if there's anything else. Mr. Mushkin?
Yeah, just a couple things, and these are
Okay.
more just kind of general comments as opposed to recommendations on changes. I think like Charlie on K,
Mm-hmm.
we were thinking like, what if a customer sends a protest letter in after a night hearing?
Mhm.
How would that work? And I think so. Like typically with exhibits, the company has, I believe it's 10 days to object after they receive it if there's something that comes in. But I agree with Charlie. I think if there could be some discretion from the chair whether to allow or disallow, would give some flexibility. So if you do run into a situation where they're providing bills, or if they, say they submit their bill and they provide some additional context, as opposed to just a blanket, they always have to do it. I think that would be helpful. On L, the feedback that I got internally was that while I don't think we've really got a problem with that language, we weren't real clear on why that was necessary for regulation. It seems like this is more the conduct of the hearing, that the chair could, as typically is done, can redirect or instruct the witness. But, I don't know that we've got a whole lot of heartburn about that. I think the biggest comment that we got back was on the cancel the customer public hearing. And certainly understand that, and not requiring the parties to expend time and effort and resources that are not necessarily fruitful. I think the question, though, that we've been struggling with, and I feel the commission's probably been struggling with too. So, for instance, in the Duke rate cases, I think those night hearings were noticed not too long after the application was filed, so a couple of months in advance of the night hearings, and so that kind of has been out there. So then the question has come up: well, if the commission cancels it, then there's still going to be people that may show up, and how do you notify the public then that it's been canceled? And so, in addition, I know that there are groups such as AARP, conservation voters, things like that, that they may be in communication with their members. They may not be a party to the proceeding, and if they've let their members know, and then it does get canceled, but AARP may not necessarily be notified. I mean, we would certainly try to do our best to, from ORS's perspective, to let them know, but I think just in practice, we're not quite sure how that would work. So I, certainly don't have a problem with retaining the right to cancel it, and the posting the notice I think is helpful. I'm just not sure how that's actually going to work in practice. So same thing y'all have been struggling with. It's not anything new as far as that goes. But that's really
that is difficult, considering the last time the commission that I'm aware of canceled a customer public hearing. It was inception of COVID, and we still drove to the site in Columbia, and people were still driving up expecting the hearing. As you were talking, Mr. Mush, the only thing I thought about is locating a facility if the commission does cancel them, the commissioners being present. We would need, in my opinion, technology so that persons who may still appear can, like virtually talk to the commissioners or testify to the commission. I don't know how this is going to work. I don't know. You understand what I mean? Because the resources that the commission uses to travel, all 7 commissioners, if they aren't appearing virtually, and what would be the best way to still not inconvenience those customers who've driven to the site and expect and hadn't received the word that the hearing is not going to proceed in the manner that they may have thought. For example, all commissioners being present. Is it okay if the commissioners are here? And if they are, we would still need tools to basically allow the persons who appeared in the community to still testify. Does that make sense? So they aren't inconvenienced.
Yeah, it does. And to be honest, I haven't thought all the way through that. I mean, the commission does have the customer virtual hearings at the beginning of the rate cases, for example. So that obviously is a mechanism. I think some part of this also along the lines of, I know the commission asked for people to pre-register, and so and I don't know how that pre-registration. I think it's in the notice that how they do that.
Yes, they do have the option to pre-register, and the notice basically states if a customer pre-registers, the commission will call those names first.
Right. And so, I don't know if there's a way to better communicate that so that people understand, as you well know, customers, they understand the concept of a night hearing, I think, of coming and making themselves known, reading through the notice and following all the instructions and going to that extra step of pre-registration, which I agree is a good thing. I'm not discounting that at all, but facilitating that in some way may help the turnout along those lines. But again, I understand the reason for proposing in. I'm just not entirely sure how that would work in practice, and there may be some growing pains with that if that comes to pass. But so anyway, those are the comments that just generally we have.
May I ask you this? Once again, I would just want your perception if you saw something like this happen. We would still have to have the capability of displaying commissioners. What if 3 commissioners were present, but the remaining are here? I mean, or what would that look like from your perception? Would that, if you were a customer, would you be offended? I know it may have made it too plain, but I don't know how better to ask that question.
I don't think I would be offended. I think if all 7 were not there, I think that could be perceived as not necessarily caring.
Okay.
If you've got 3, I think that would be an interesting split. I think that would, for instance, I know in whether it was Commissioner Justin Williams or Commissioner Belser, I think had to appear virtually. I think, I would assume customers generally understand scheduling things along those lines. So I think that would probably be more palatable than just doing it all virtually.
Okay.
Yeah.
Just curious from your perspective what that may look like.
Right.
Yes, sir, Mr. Terraini.
There's one more thing that occurred to me. It really doesn't have anything to do with my client, but in a public witness must be a customer of the party that initiated the docket, and that makes perfect sense to me in rate cases and so forth. But we have cases at the commission that are either not initiated by a utility with customers that may require a public hearing, thinking of citing, for instance, or cases that are initiated by a utility, again, citing, but there may be others. I have not thought this through, that, like, for instance, transmission lines could affect a lot of people that are not customers, or utility sewer extensions. I mean, I'm just putting it out there. I recognize the need to limit this in certain cases, particularly rate cases, that kind of thing. I'm not sure that it applies that way in all cases.
That's a great point. Okay, Mr. Terraini, what about a public witness must be a customer of the public utility that initiated the docket at the commission, if applicable?
Well, the public utility could initiate a docket,
but I understand
for a matter that affects non-customers, right?
Okay.
Jocelyn, one thing you could do, kind of like we did with Charlie's other suggestion on whatever number that was, K, is accept as otherwise allowed by the commission, or
that's a good idea.
something to that effect, as opposed to trying to define every circumstance.
I agree. That's a good idea, man.
Should we say at the discretion of the chair? No, that's not really the right words.
No, I think that'd be fine. Something to that effect, I think would be fine.
All right. Thank you for that. Both of those. May I go back to you, Mr. Terraini, and then I'll come back in the room. What did you think about just if let's say 5 people pre-register and the facility is able to accommodate the virtual appearance of 4 of the commissioners, would you be offended as a customer or even as the entity who filed the case, initiating the docket?
No, not necessarily. I've seen legislative hearings that have been held like this, where, for instance, Judiciary Committee in the Senate would have hearings on site in different parts of the state for redistricting. to get public input, and not every senator on the committee could make it, but they would participate virtually, and you'd have one or two or three in person. And everybody's, I mean, those were well-attended hearings. Everybody seemed fine with it. It was kind of COVID-ish. I mean, it was right after the lockdown, so maybe folks were not as surprised by that, but I don't think so. I think it would be fine.
Yeah, we just need to make sure we have accommodations, virtual accommodations. Mr. Anselmo, Mr. Burgess, do you have any thoughts?
You're asking us from the perspective of a customer,
Well,
whether or not
I'll
we would
ask
be.
you from the perspective of the company. If three commissioners, depending on the number of pre-registrants, appear in person and the other commissioners appear virtually, your perception?
Sure. I mean, I think whether or not a commissioner wants to come to a public night hearing or not, I think is within their discretion. The company would not have an opinion, good or bad, whether or not they showed up. I think that should be left to them.
Commissioner, okay. And Mr. Trawick and Ms. Henderson, do you have anything you want to share?
No, we agree with Dominion. I think that's
Okay.
up to the individual discretion and frankly schedule of the commissioner.
Okay. 1, 2, 3. Okay, that's 4 people. 4 stakeholders. Well, everyone, I don't have any other
Miss-
Can we?
Miss,
Oh, I apologize.
Mr. Torini and Mr. Mushin had a little back and forth about subsection A.
Yes.
I would like just to note that Act 41, subsection E, says the commission may convene public hearings to allow public utility customers to address the commission on various topics. So just be cognizant that the act itself is limited to public utility customers.
Well, I would agree with that. Other than in the citing act, there is the citing portion of it. There is language, as I recall, about having hearings in the location for citing act cases.
Yeah.
So while I take your point and I don't disagree with that, there's other provisions that talk about customer hearings.
Yeah, I might have misread. I think perhaps I was reading the draft mock-up maybe too restrictively to be Act 41 related customer complaints. Maybe I should look at the title of this thing a little bit better.
And if it's limited to that, I mean, I don't have a problem with that. I guess my point is, so for instance, we've got 2 citing cases that that there have been local hearings been requested in the area, and so they're not.
Yeah.
So, for instance, a solar company. Well, it's not. There's not a customer, and so I don't think we want to say the commission can't have a night hearing in those types of situations, or because there is no customer.
Yeah, I agree. Let me caveat my comments by saying that if it's any customer hearing authorized by Act 41, the General Assembly says it should be limited to public utility customers. If there's another statutory provision that authorizes customer complaints in the context of that specific docket, I think you'd have to adhere to the language of the General Assembly there too. Right, Ben?
Well,
I mean, y'all's goal, and I completely understand and agree with it, is you don't want people showing up at a rate case that aren't customers of the company. Totally get that. So you got no argument with me on that.
Can I propose a unifying edit?
Sure, please.
Bring us together, Lyle.
Real mediator here. In subsection A, could we just add a comma unless as otherwise provided by law?
Mm-hmm. What do you think,
Beautiful.
Mr. Anselmo?
That's why Lyle's smarter than me.
Because I agree. I think Act 41 does require this, but to Mr. Bush's point, certainly citing act proceedings are a bit of a different animal. So I
Yeah.
think that gives the appropriate intent and flexibility.
Thank you. Did you hear that, Mr. Torini? So A can read, a public witness must be a customer of the party that initiated the docket at the commission unless otherwise provided by law.
I think that works.
Thank you. Okay. Mr. Anselmo and Mr. Burgess, do you have anything else right now?
Nope. Thanks again for the time.
Thank you. Mr. Trawick, Ms. Henderson,
No, thank you.
thank you. Mr. Torini,
No, ma'am. Thank you.
Thank you, Mr. Mustian. Okay, thank you. So everybody, I'm going to, we're going to amend this based on our discussions today, and we'll put draft watermark on it and then upload it to DMS. The heading at the top with the scheduling the workshop today will not be included. Then we'll serve you with that, okay? Serve that on everybody. Thank you for your hard work. We appreciate it. I don't know when I'll see you again, but have a good day.